In a typical mediation, we know that the parties to a dispute mediate, and if they are successful, they settle their disputes and draw up a settlement agreement. In an ideal world, the parties comply with the terms of the settlement agreement. But if one of the parties refuses to comply with the terms, what does the innocent party do? One of the major grievances against mediation is that its outcome, that is the mediated settlement agreement, is difficult to enforce in the event of non-compliance. Mediation is often placed on a lower pedestal than other dispute resolution processes for this very reason. Until the Mediation Act, the parties who want to enforce a settlement agreement typically take three routes. First, the contractual route. Sue on the settlement agreement for breach of contract, or take the consent judgment route or consent award route. In such cases, they start litigation or arbitration, then mediate and settle, get back to the court or tribunal with the settlement terms, and get a consent award or judgment, as the case may be, on those terms. Obviously, none of these routes are particularly attractive. In all these cases, the parties have to initiate litigation or arbitration, exactly what they want to avoid in the first place. It is in this context the Mediation Act provides that much needed bite to the mediated settlement agreements. It does three things. First, it defines a mediated settlement agreement and set formal and substantive requirements for a valid settlement agreement. It defines a mediated settlement agreement as an agreement resulting from mediation between the parties settling some or all of their disputes. Quite straightforward. Formally, a settlement agreement must be in writing, it must be signed by the parties, authenticated by the mediator, and copied to the parties as well as the mediation service provider, if any. Registration of a mediated settlement agreement is also provided for, but it is optional. And substantively, a settlement agreement must not be a void agreement under the Indian Contract Act. As such, settlement agreements whose considerations and objects are unlawful, which are uncertain, which are made without consideration, made by way of wager, etc., will not be deemed to be a lawful settlement agreement. Now, secondly, mediated settlement agreements, once signed and authenticated, are made final and binding on the parties. Final and binding. They are enforceable in the same manner as they are a judgment or decree passed by a court, as if they were a judgment or decree passed by a court. The Act does not stop there. Thirdly, to prevent parties from indiscriminately challenging such settlement agreements, it imposes certain substantive and procedural limits on such challenges. A challenge can be made only on limited grounds: fraud, corruption, impersonation, and non-mediatability. And a challenge has to be made within 90 days from the date on which the challenging party has received the copy of the authenticated settlement agreement. Of course, a further 90 days if there is sufficient cause. This enforceability of mediated settlement agreements is one of the key features of the Mediation Act. It gives mediation that much needed bite and makes mediation as attractive to the parties as any other dispute resolution process.